Good morning again. So we're going to resume our discussion around monitoring with this panel focusing in on monitoring international cooperation and human rights. And we have three panelists here with us this morning, all talking about different dimensions of monitoring international cooperation. And our first panelist is Sierja Brady. She is a very experienced human rights monitoring expert. She's working as an independent research consultant. She has recently authored the Irish Human Rights and Equality Commission's submission to the Committee on Economic, Social, and Cultural Rights. She's done a number of other types of reporting, not only under the ESC treaty, but also the Covenant on Civil and Political Rights. So we are looking forward to hearing her ideas and her thoughts around monitoring under the international human rights reporting processes.
So, first of all, I'd like to say that it's great to be here. I've learned a lot in the morning, so I can only imagine how much information you've all taken in already this week. And I really wish that I was standing up here and talking to you about parallel or shadow reporting under CPRD, but given that Ireland hasn't yet ratified that covenant, I'm talking to you about ICESCR, the International Covenant on Economic, Social and Cultural Rights. I'm going to talk very much about the practicalities of it, about the process. And I know Frank, a member of the Irish Human Rights and Equality Commission, is going to talk more about the Commission's involvement and also make some observations on the recent process as well. Just to clarify that this presentation is about the civil society report that I was involved in. I was a consultant on that report as well under ICESCR. So I'm going to talk you through the process a little bit. I'm sure many of you are familiar with treaty body monitoring processes and shadow and parallel reporting under that. But just for those of you who aren't, I am going to kind of start at the beginning and talk my way through it. So just to give you some background, Ireland ratified the Covenant in 1989. Now this Covenant came into being in 1966, so we certainly took our time about ratifying it. And we've agreed to comply with the provisions of ICESCR with two reservations, and those are around homeschooling and Irish language in certain professions. They're not relevant for today's discussion, but just to note them. And under the Covenant, as part of the Covenant, when we ratified it, we agreed that we would submit periodic reports for review by the Committee on Economic, Social and Cultural Rights, which is a committee of 18 experts who meet in Geneva a number of times a year for 3-week periods and examine states. Before this, prior to this, we were last examined in 2001. So obviously, times have changed in Ireland since 2001. The concluding observations by the committee were given in 2002, and they said things around, we don't see any impediments to Ireland progressively realising the rights within this treaty because, obviously we were going through boom times then. We've since had a recession and apparently we're now in recovery. So, we had to look at a whole range of issues that had come up. The state submitted its report in 2012. And just to note, when they submitted that report, they only actually covered the period from 2002 right up to 2010. So already it was out of date when they submitted it. And then because of the backlog with the UN process, with the treaty body itself, the date set for our examination was June 2015. There was a process where we went and presented to the committee in December 2014, which I'll talk a little bit about. But so the state did send in a very short update in April 2015, which updated some of the material. But certainly without the parallel reporting process, I think that the information the committee would have been very out of date already. So just to cover some of the rights enshrined in ICESCR, I'm sure most of you know, but it's the right to equality and non-discrimination, right to health, education, social security, work, just and favourable conditions of work, a right to an adequate standard of living, and a right to cultural life. So when we talked about cultural life, we actually talked about things like language rights, so Irish language rights, recognition for Irish Sign Language, and traveller ethnicity, recognition of traveller ethnicity by the Irish government. In terms of the ISASCO reporting process, from the state's point of view, the state submits its progress report. In this case, it did that in 2012. And then the committee decides on a list of issues. So it decides on a list of questions for the state in response to the state's report. So basically, back in December last year, a subgroup of the committee met. So 5 members of that committee met and talked to both the National Human Rights Institution and also civil society separately in closed sessions so that we could have a very frank and open discussion with them around some of the issues that we felt they should ask the government. So that happened at the beginning of December 2014, and a week later they issued the list of issues. Once that list of issues comes out, the state actually has to respond to it in advance of the examination. So they did respond in April 2015, and basically, if you look at the list of issues response that they gave, and I've put all these documents in the Dropbox folder as well, but they dealt with certain areas, and basically what they do is they divvy out the various sections to the relevant departments. So you see differences in how they approach answering the questions that they've been asked. The next step is the committee examines the state delegation in Geneva. So I know you had Minister of State Sean Sherlock here on Monday, and he actually represented the government in Geneva. He led the delegation, and it was a delegation of a number of different civil servants from different departments who went along with him, who would have the expertise and knowledge in the various subject areas, so they could answer them. And then after that, so that happened on the 8th and 9th of June 2015, a number of us went to Geneva, and then 2 weeks later they issued the concluding observations, the recommendations for the state, and we'll talk a bit about those in a bit. So often I get asked, particularly given I've been involved in a few of these processes now, why bother submitting a shadow or parallel report? Usually, and also just to say, in the Irish context, we usually talk about shadow reports, but at the UN level, certainly there's a move towards talking about parallel reports, because that kind of puts those reports on a parallel basis with the state report and kind of shows that they are important. Whereas some people at the UN level would see shadow as maybe not or showing the importance of these reports. But I've used both just for ease of understanding. So one of the reasons why we did it, and we've done it before this as well, obviously, but Ireland is currently a member of the UN Human Rights Council. They really wanted to be a member of the UN Human Rights Council, and they've done quite a lot as members of the UN Human Rights Council. They have drawn attention to human rights abuses in certain areas. But what we wanted to do is draw that attention to their upkeep of human rights standards at home and look at it on the domestic level. We felt that we could influence what questions the committee might ask, what recommendations they might make, and we did that by going along to the pre-sessional working group meeting, talking through some of the issues with them, and those did appear in the list of issues, and then they did, a lot of those issues that we raised in Geneva, both the National Human Rights Institution, the IREC, and the Irish Human Rights Equality Commission raised a number of issues, but also civil society did as well. And if you see the concluding observations, they're quite detailed, and a lot of that detail came from the reports that we submitted. And then lastly, I know earlier we heard about, media attention for these processes. And what we really wanted to do is focus an international spotlight on national issues. Yes, sometimes it's about embarrassing the government a little, making them feel uncomfortable in their seats when they're talking about issues elsewhere, but they haven't, sorted out their own house. So there is an element of that. And we have concrete examples from other UN committees where the recommendations did result in concrete, tangible results. So, for example, the Ombudsman for Children's Office was set up on foot of a recommendation by the UN Committee on the Rights of the Child. We've had that office for more than 10 years now. We had our Taoiseach, the Prime Minister of the country, issue an apology to women who have been systematically abused in institutions, women who were unmarried mothers and kept in these institutions for quite a number of years. And he issued an apology, and I've spoken to the Justice for Magdalene's group, and we agree that maybe what happened after that wasn't perfect, but certainly that apology meant a lot to a lot of people. And I don't think that would have happened certainly without that international pressure, that international spotlight being put on the government to do something. So when we found out all the dates, when we found out that we were going to be examined, the state was going to be examined in Geneva in 2015, we talked about coordinating a parallel report. Now, for the International Covenant on Civil and Political Rights and for the UN Convention on the Rights of the Child, there are organisations set up that naturally fit with those. So, for example, the Irish Council for Civil Liberties led on the ICIPR, the International Covenant on Civil and Political Rights. The Children's Rights Alliance, an alliance of over 100 different members, leads on the UNCRC shadow report. Before ICESCR, it spans so many different issues, so many different groups in society, so there wasn't naturally someone who was going to lead. But the Free Legal Advice Centres, FLAC, they talked to other people in the field to see if they were doing anything, and we felt there were strength in numbers, that having a coordinated approach to this is something that committees actually value, because they like to get one comprehensive report. Now obviously everyone puts in their own submissions as well, that might give more detail, but certainly if they have one comprehensive report that spans a whole range of issues, and then it's endorsed by quite a number of NGOs, civil society actors, they can take that and really use it. So that was one of the reasons why we felt it was worthwhile to coordinate. And as I mentioned before, I carried this out on a consultancy basis for FLAC. I used to work with them, so I would know the organisation very well. They have a project called the Public Interest Law Alliance, PILA, and it works with NGOs. It has a network of NGOs, and it tries to show them how you can use law to really achieve and affect social impact. So they had that existing network, so they were able to use that. We also had strategic decisions made on the content of the report, and that was informed by consultations and guidance from an advisory group, both of which I'll refer to in a second in more detail. And we sought endorsements, as I mentioned, from other NGOs and stakeholders, and we had over 80 endorsements for the final report, which it demonstrated to the committee that we were organised, that we were coordinated, and that we agreed on a lot of these issues as well. So just in terms of the steps taken to produce the report, this is quite basic, but I think it is just kind of sometimes useful to talk about the practicalities and how we went about it. So we designed and circulated a questionnaire on key questions and updates, and what I used to do that was I looked at what the committee said, how they have broken down the rights, looked at the general comments on how they interpret the different rights and the different components of those rights, and kind of set that out in visual diagrams for people as well, to try and break it down, that the right to health isn't just about being healthy or able to access a hospital, but it's about the affordability of healthcare, it's about so many other things. So all of those materials are available online as well, and I've given you links to them, so you can look at those and come back to me with any questions if you have them. It was very important to hold public consultations, that it wasn't just desk-based research, that we would go out and talk to various people. We did that through the PILA network, through the network of NGOs that we had worked with, that we all knew. We put out the call, we used online and social media as well, and we really tried to get as many people involved as we possibly could, and student networks as well were obviously very important. And we then drafted the content of the report, but that was very much informed by written submissions that we received, and by the consultations, and by the expertise of the NGOs and stakeholders that we had. We circulated the draft for feedback so that people could feel ownership over the information as well. And we incorporated that feedback into the final draft and held a final consultation to talk about why certain things mightn't have been included, why we had made such a recommendation. Was that the right recommendation to make? How would you rephrase it? How could we make it stronger? So we did that, and we tried to get as much involvement as possible. As part of this, we established an advisory group and identified key stakeholders and contributors. So in terms of the advisory group, I'm certainly not an expert on a lot of these things, on housing, education, disability, and we had Eleanor actually was on the advisory group in terms of disability, as social security and ESC rights, both in the Irish and international context. So we would love to have had a bigger advisory group, but that also wasn't, it wasn't practical. And some of these people weren't actually in Ireland either, so they were given feedback by email or by Skype. So we did have to control it, but we felt that these were very much cross-cutting issues that we had to cover in the report. So that's why we had chosen experts in those fields. And as I mentioned already, we used existing networks to identify key stakeholders, and we used a lot of online media. So we set up a separate website, and there's a lot of blog posts in there. So we got people to input blog posts after the final draft of the report was finished and in the lead up to the examination. So we built some momentum around and excitement around the examination, because we felt it's 13 years since we've been there. It's 13 years since we've talked about all of this. So, we should take control. We should take some ownership over it. And we tried to engage with members of the public and also with NGOs or organisations who don't traditionally use rights-based language or monitor human rights. They don't see rights as something that has anything to do with their work. So we tried to talk to them about the issues that they did see and show that they did fit in with this report, and that the information they could provide was invaluable for it. So the specific details of the Our Voice, Our Rights report, and that's what it was eventually entitled, because it was a collective voice around our rights. Public consultations took place in May 2014, so there was a long lead-in. Even though we knew it was June 2015 before we were going to be examined, we did have quite a long lead-in to it, and there was obviously a lot of prep work before this. But we held regional consultations in Galway, Cork and Dublin. We held one here in NUIG. And then we held thematic consultations on housing and social security, because we saw that those two issues really impacted right across the lifespan, right across various groups. We were talking about travellers, we were talking about children, we were talking about older people, people with disabilities. So, these things really have an impact on everyday life for so many different groups, that we felt it was worthwhile doing that. We received 23 written submissions. This was for the initial report. We received a lot more after that for the update. But and so what we really tried to hammer home to people, though, is we knew things were happening on the ground. We had the anecdotal evidence, but we needed proper, real, tangible evidence. We needed statistics. We needed reports. We needed to be able to document this, because when you're going before the committee and you're giving the committee this information, they will ask you, is this accurate? And if you look at both the ISESCO reports that go in, they run into hundreds and hundreds of footnotes, and that's so that we can stand over everything we said, that that the government couldn't come back or try and put a spin on it or say actually that's not accurate. We were very, very careful to only include information that could be documented. So we we sent the draft report round to all the participants for consultation in September 2014. And even at that stage, we had people who hadn't been involved in the initial draft come back to us with feedback. And we got quite a lot of feedback. We put together a questionnaire. We asked them to provide specific examples or reword where necessary. If they were the experts in the issue, tell us what we should be saying or how we should be presenting it. We submitted it to the committee on the 1st of October 2014, so we sent it over to Geneva. They needed it a couple of months in advance before they held their pre-sessional working group. I have to say the committee that we met, certainly they're very hard-working. They all have day jobs and they do this on a voluntary basis, and they come to Geneva and they're inundated with information. So, it's quite a feat that they seem to be able to get through it all. And then, as I mentioned, I attended the pre-sessional working group meeting on the 1st of December. It was a closed session. At that session, it was only me representing civil society, and that was for a number of reasons. It was around the time of Human Rights Day or the lead up to it, so a lot of events were on. Funding issues for organisations, they had to make a choice between going to the pre-sessional or to the actual examination itself. So there were a number of reasons for that, but it was a closed session. But that isn't always the case. For example, the Committee on the Rights of the Child met to determine the list of issues for Ireland for next year's examination under that. And they had a 2.5-hour session with a number of different organisations who had travelled to Geneva for that, and also a session with the young people themselves, a closed session. So it depends on the different approaches that you can take. And then the list of issues was published in December 2014, which were clearly influenced by the conversations that they'd had with the Commission and with the civil society delegation, which was me. So just to say as well, in the final consultation we had talked about, like the report is, you know, pretty hefty. So we had to prioritise. We had to talk about issues that people agreed on and what were priority issues. So we had done that in advance of going to Geneva. So we had about 10 issues, and there is a presentation on that as well on the Our Voice, Our Rights website. So you can see what exactly we had presented to them. So in terms of disability rights and ISESCR, I'm not going to go through this in huge detail. I know Frank's going to talk a little bit more about the process as well. But just to say that, you know, as I mentioned, disability is such a cross-cutting issue that a lot of these rights impacted specifically on persons with disabilities, and very clearly. And back in 1994, the committee had drafted a general comment, an interpretive comment on persons with disabilities and ISESCR to talk about equality, non-discrimination, but to talk about some of the specifics as well. And then in the general comments as well, you can see where they talk about persons with disabilities and in relation to particular rights. So social security obviously was a huge issue in terms of the payments, which do not reflect the cost of living for a person with disabilities here in Ireland. And there have been cuts to payments for persons with disabilities, and there have been cuts to the payments for their carers as well. Housing and accommodation is a huge issue. Right across the board, but particularly for persons with disabilities. Employment given, and that wasn't just the low rate of employment or part-time employment of persons with disabilities, but also the quality of work that they were offered and whether or not that work was recognised. So we looked at that as well. Health and mental health. We had quite a number of people come forward on the mental health issue. A number of advocates or community-based groups who traditionally wouldn't have used rights-based language, but they did. Like, we had a lot of input on the mental health side of things, education, particularly for children with special educational needs. One of the things that is very clear in this report is that we have a lot of strategies, we have a lot of pieces of paper that say a lot of great things. And of course, when the government went to Geneva, they were saying, well, we have a strategy on this, we have a strategy on that, but there's no implementation, there's no resources, and that's something that's key. And that was something that we really wanted to flag with the committee. And the adequate standard of living obviously is a huge issue for so many people in Ireland today. Looking at poverty rates for particular groups. One of the things that came out of the concluding observations, which I think is so important, was the data. The committee came back and said, can we get disaggregated data? And they asked by disability as well as by year, gender, etc. But the data was outdated, and then there were disputes over which data we were using compared to which data the state was using. So that is hugely important. I'm not going to spend a lot of time in the concluding observations because I want to leave plenty of time for questions, and I know Frank's going to discuss these as well. But one of the key things that they've said in every time we go near any of these committees is ratify CPRD, and we did have a commitment in 2011 by our then Minister for Justice and Equality that we would ratify CPRD, but we still haven't. So that did come up during the discussion in Geneva, and they still have not done it. They also asked for the state to take all necessary steps to make available alternatives to institutionalisation. And this morning we saw what the impact of institutionalisation can be, at its worst, but also in terms of providing more community care and community services. They did talk about that, but not in a huge amount of detail. And they talked about enhancing the accessibility of persons with disabilities. And one of the strongest recommendations maybe in it was that they called on the state to cancel the cuts on social benefit programmes. So they looked at where those cuts had been made. And this was specifically in relation to disabilities, because there have been cuts made to other groups such as lone parents, young people, etc. But this was a very focused recommendation, I thought. So there's lots of links there for you to look at. What I would point out to you is the Our Voice, Our Rights website. There's a lot of documentation on there, both, and it's all in the one place. So, you have the civil society inputs. You also have the National Human Rights Institution inputs up there as well, the state inputs. But one of the other things that FLAC did, unfortunately, we were due to live stream the session in Geneva so people could watch it from home and watch it in the workplaces. But that didn't work out at the very end. So what they did is they put together a Storify. So they were putting together all the information around the tweets that were coming in, blog posts, photos. So it kind of gives you a sense of what happened in Geneva. So if you just want a very quick overview of what happened, what kind of issues came up, I'd recommend that you look at that. I've also included the really boring side of things, the primer documents, the information for civil societies, and the general comment. And Amnesty Ireland also issued a guide to shadow reporting under ISESCR a number of years ago when we thought that the examination would happen much sooner. They had started doing some work around health and housing, but that was back in 2007, 2008, that kind of time, and then of course there was a huge delay. So they had put together this guide to shadow reporting. Now they were an observer on the civil society side of things because they have their own internal processes and they submitted their own report in the end. But they did, we worked very much with Amnesty to ensure that we captured their issues as well. So that's really a very quick whistle-stop tour of ISESCR from the Irish point of view, and I'd be happy to answer any questions anyone has.
Thank you, Sergio. Great presentation. Don't feel too bad about Ireland not ratifying the CRPD yet. I'd be here all day if I were to catalog all the treaties that my country has failed to ratify. CEDAW, CRC, CRPD, Law of the Sea Convention, International Criminal Court, goes on and on. But I think we've heard here a really fabulous case study of how to harness the UN human rights treaty system and to advocate for ESC rights. I think it really makes the point that these treaties are for disability rights advocates, whether it's CRPD or another treaty process. I think that's really essential since disability is such a cross-cutting issue. And I think one of the takeaways for me is that you really emphasize the importance of the process, and the process being inclusive and participatory and consultative, and that gives the report its legitimacy and its heft. And I think that's really important. You're not going to have a legitimate report unless it's really inclusive, and ideally you're going to have the kind of broad coalition that you talked about. It's going to have more legitimacy, and it's not only preparing a parallel report, but it's also engaging in the list of issues, basically the questions that are put to the state in the interactive dialogue, as well as preparing a parallel report and trying to feed into the concluding observations and recommendations that can then be used as a tool in furthering advocacy post-reporting process. So our next presenter is Miriam Natunge. She is one of our very own here, an LLM student here at the center. She is coming from Kenya, and she worked previously at the Kenya National Human Rights Commission. And one of the things she has been focusing on is legal capacity as a member of the Legal Capacity Network in Africa. And she's doing her LLM here with a focus on Article 33.2 of the CRPD. Recall that is the provision which focuses in on the requirement that states ratifying the treaty establish or designate an independent national monitoring mechanism. So looking forward to hearing about your work.
Okay, I must admit that I don't know how I'm going to talk about this in the next 20 minutes. Is it 20 minutes or 15 minutes? Because basically, Article 33 itself, it's a whole presentation, and you have to give like a background of what it all entails. But I'll try as much as possible to summarize my presentation and make sure that by the time I get the 1 minute warning, I'm done with my presentation. But basically looking at what we have been discussing since the summer school started on Monday, we have been talking about the challenges that we have been facing. We have been talking about how to bring international, we should talk about development and issues of persons with disabilities. And we have also been talking about how we are trying at the domestic level or at the national level to have discussions with the key actors. So my presentation talks about the national mechanism of monitoring. My colleague here has tried to talk about national monitoring, but at the same time bringing on the issue of the international monitoring. And this goes back to the negotiation of Article 33.2. What exactly did the state want? What did the delegations, including civil society, including non-governmental organizations, what exactly did they want from this article? And it was basically more than just monitoring. It was more of moving from the reactive monitoring aspect to a positive monitoring aspect that not only monitors, but actually socializes people or actors themselves to be able to influence the actual compliance itself. So basically, my presentation will be talking about Kenya. We have ratified the Convention on Rights of Persons with Disabilities, and I am going to share my experience at the Kenya National Commission on Human Rights. And during my time at Kenya National Commission on Human Rights, that is between 2012 and 2014, I was basically focusing on Article 33.2, talking about implementing activities, focusing on national monitoring, and the three aspects of Article 33.2, which is promotion, protection, and monitoring. Oh, I have to make a disclaimer. I talk very fast. So if I talk very fast, please raise your hand. Yes. So I'm going to talk about the three aspects, and I will give you a background of Kenya, where we are in terms of our laws. We have one of the progressive constitution, I have to say so, Constitution of Kenya 2010, and Article 2.6 of the Constitution states that any international instrument that has been ratified forms part of the domestic law. So once you ratify the CRPD, it's applicable in the courts. So you don't have to have discussions in the court, in the parliament to domesticate it. So definitely the ratification itself makes it part of our law. In terms of persons with disabilities, we have 4 points, according to the report that we have, Kenya National Survey for Persons with Disabilities, we have 4.5% of persons with disabilities of the total population, but we think this is underestimation looking at what the statistics at the WHO report talks about. And I've talked about the Constitution, we have the Disability Act, we have a specific article actually in the Constitution that talks about rights of persons with disabilities, and we have Article 27.4, which talks about non-discrimination, and it talks about groups that have been protected, that have been protected under the non-discrimination clause, and persons with disabilities are included. Then we have the policy framework. We have the National Disability Policy, which is still a draft since 2006. We are in 2015. We have the Public Service Disability Mainstreaming Code. We have the Special Needs Education Framework. And then in terms of the institutional framework, we have the National Council for Persons with Disabilities. We have the Ministry of Labor, Social Security, and Service. Department of Gender and Social Service is the one that handles issues of disability. We have the Kenya National Commission on Human Rights, which is the National Commission on Human Rights, National Gender and Equality Commission, which is the equality body, and then we have the Commission on Administrative Justice, which is the Office of Ombudsman. So I'm basically going to talk about the Kenya National Commission on Human Rights and the work it was doing before the work was shifted to National Gender and Equality Commission. That was in 2014. As we've been talking about paradigm shift, we have been talking about the social model, we have been talking about human rights approach in the convention, and then we have the structural shift of the convention, which is basically Article 33 on national monitoring and implementation. And I must say that one thing about Article 33 is that it is actually contained in the main text. So unlike the optional protocol, which provides for national preventive mechanism, which is actually in the optional protocol and not the main text of the Covenant Against Torture, what the convention does is that provides the text on national monitoring in the main text of the CRPD. So if your state ratifies the CRPD and does not ratify the optional protocol, it's still obligated to designate independent mechanism to monitor implementation of the convention. So I'm not going to read everything about Article 33, but basically Article 33 talks about three main things. It talks about designation or establishment And basically, if you look at those two wording, it means that designation is an existing framework, and establishment means that building up a new framework, and then you appoint it or you assign it to be the independent mechanism to monitor the convention. And then it talks about one or more independent monitoring mechanism, so which means that a state that has ratified the CRPD can designate one or two or more depending on its domestic mechanism. For example, right now we have three bodies we have the National Gender and Equality Commission, and we have the Kenya National Commission on Human Rights, and then we have CAJ, the Commission on Administrative Justice. But basically, we have moved from the National Commission to the Gender Equality Commission. And going back to how everything was done in terms of designating the independent mechanism in Kenya, I'm happy to have Elizabeth Kamuntia here. She was originally there. She was one of the people who initiated those activities at Kenya National Commission on Human Rights, and I picked up from her when she came here to do a LLM. So what happened is that after ratifying the convention, discussions began with the Kenya National Commission on Human Rights and the DPOs, and from this discussion of how to domesticate the CRPD, it was suggested that now the Kenya National Commission on Human Rights, because it's the National Commission on Human Rights, and because it's the National Human Rights Commission it's the National Commission on Human Rights, and it actually complies with the provisions of Article 33(2). It is an A-status accredited organization, and it had previous experience on issues of disability. It was more appropriate for it to be designated as an independent mechanism. So what happened was that to inform the Office of Attorney General of what the discussion was all about, and after that it was designated as the independent mechanism in February 2011, and then activities began. So what happened was after that, there was the designing of a monitoring tool, and the monitoring tool captures the various articles of the CRPD, and then all this, the designing of the monitoring tool involved DPOs, persons with disabilities, and non-governmental organizations that works on issues of disability. And then after that, there was a design of monitoring surveys, which was supposed to be done in 47 counties. After promulgation of a new constitution, we now have a bicameral system. We have the national system and we have the county system. So monitoring was done not only at national level, but done also at the county level. So the structure was that by the year 2015, we'll have the 47 counties having been monitored, and the survey was basically targeting institutions of learning, homesteads of persons with disabilities, hospitals and social places, government institutions, and financial institutions. And other than the surveys, the role of KNCHR itself as the National Commission on Human Rights gave a way for us to mainstream issues of disability in its framework, and basically the role of protection and the role of promotion and protection. Because if you look at the work of National Human Rights Institution, they have the role of creating awareness, they have the role of litigating, they have the role of submitting amicus briefs, and then they have the role itself of submitting shadow reports, parallel reports to treaty bodies. So all this was mainstreamed. Our work on promotion and protection and monitoring of rights of persons with disabilities in accordance with Article 33(2) was mainstreamed in our initial work on promotion and protection of human rights, like general human rights. And then we had specific activities for monitoring. So while we had the mainstreaming, and I have to emphasize this, because basically when I'm going through reports of the bodies that have been designated as independent mechanism, you see that there's that mainstreaming approach. But the mainstreaming approach itself is not going to yield the results that we want. If you're an independent mechanism, for me, my argument would be have mainstreaming activities and have separate activities basically targeting issues of disability. Because it has been when you mainstream activities, then disability issues becomes something that you are going to discuss later, something that is not going to be there as a topical issue. So that has been that was the approach that we use. Have very specific activities on issues of persons with disabilities, and again, mainstream your work within whatever you're doing at the independent mechanism. And again, you move out of the commission itself, you involve yourself with the work of the DPOs. So what happened at the National Commission on Human Rights? The National Commission on Human Rights became a member of the Disability Caucus on Implementation of the Constitution, which is an umbrella body for DPOs that work specifically on issues of how to implement the Constitution, basically focusing on Article 54 and Article 100 of the Constitution and other articles of the Constitution to make sure that while we are implementing the Constitution, we are able to flag out issues of persons with disabilities. So Kenya National Commission on Human Rights was a member of the Disability Caucus on Implementation of the Constitution. So we would go and support the DPOs, and we are able to submit advisories together, and that was another way of making sure that we involve DPOs, because Article 33.2 talks about, 33.3 talks about involving persons with disabilities and their organization in the monitoring, specifically on the monitoring process. So we basically tried as much as possible to make sure that we involve persons with disabilities, which is the principle of the convention, that persons with disabilities have to be involved in all the processes, and not just about involvement, but be actively involved and effectively involved in every process. And in terms of the key outcomes of the activities that we had in terms of promotion and monitoring, we had the discussions that began in 2012 about Article 12 of the Convention, which is on equal recognition before the law. We had discussions about here on issues of legal capacity. And I must say that some of the questions that were coming in during Alberto's presentation about how to engage with judges, how to engage with some of those very senior people within government who basically may not be very flexible to some of the argument. One of the things, a plus for independent mechanism, which is a National Human Rights Commission, is that because of that legitimacy at the national level, because of that legitimacy itself that it gets because it is a national human rights institution, when it starts a discussion, it's actually, the other actors really listen to them if they have that relationship. So for us, beginning the discussion about Article 12 and getting the DPOs who were initially also doing the work, we were able to engage with judges, we were able to engage with other international organizations, and we are able to do so many activities within that framework that we had. So it's basically about the legitimacy of the organization, the legitimacy of the institution that is designated as the independent mechanism. And then we were able to come up with a report on monitoring, and this report is available at the Kenya National Commission on Human Rights website. If you look at my presentation, you'll be able to see the hyperlink that will link you to the report, so you can be able to read more about the report. But basically, the report was able to highlight what the progress, what needs to be done, and I will not comment so much about implementation of the report, because when I left the Kenya National Commission on Human Rights, the report was just being launched a month after I left. So in terms of recommendation, how the recommendations are being implemented, I won't comment so much about it. So because this conference is all about international cooperation, international development, I try to single out how in our implementation of Article 33.2, we incorporated international cooperation. And I singled out 3 aspects of it: the funding part of it, the technical expertise, and the sharing of best practices. So if you go back to our activities and how they were funded, we had a co-funding strategy. We had the government funding or facilitating hiring of personnel and part of the work on protection. Basically, the cases that were being litigated during that time, which most of them were more of us being incorporated in as amicus, were funded by the government, because we have the complaints and investigation department that deals with issues of litigation. So basically that was funding by from the government. And then we had the development partners coming in. For example, the work on monitoring and research on legal capacity was co-founded by Dutch Embassy, United Nations Development Fund, and Open Society Initiative for Eastern Africa. And then when it comes to technical expertise, specifically on the work on legal capacity, we actually tapped on experience from experts from the Center for Disability Law and Policy here in Ireland. We had Canadian Center for Community Living, we had Open Society Foundation, we had Mental Disability Advocacy Center coming in, and Inclusion International, and other independent other independent experts who came in during our research and gave feedback. And this actually built on on our experiences of Article 12, and we were able to single out some of the arguments that really fitted in our national level. So basically, that's all about technical expertise, and then about sharing of best practices, because we are one of the countries that has been able to establish an independent mechanism. We received a number of delegations from other countries who came to learn about how to implement Article 33.2 within their countries. We had representative from Burundi, we had representative from Ghana, we had representative from Uganda. And I remember for Uganda, they were specifically asking about election monitoring, which we did during our elections were held in 2013. We participated in monitoring, and we were just sharing experiences. So basically, when you're looking at how Article 33.2 interacts with Article 32, you single out some of the aspects that you are going to incorporate in your work when you are implementing activities. And for my conclusions, I will draw out some of the lessons that we learned from our trials. I must say it's trials because it's not a perfect way of doing it. We are still trying to polish it up. So in our implementation of Article 33.2 on monitoring, some of the lessons that you can draw from that experience is that, for one thing, Amoni State, that is a state that international law applies immediately after ratification, it's a plus. Because for us, we didn't have to wait for so long. We have seen the CRPD being used in courts. We had a case on legal capacity. We had references being made on Article 12 for the first time. So that is a plus. And again, I'm talking about vibrant disability movement, which is very crucial for Article 33.2, because you can speak as National Human Rights Commission, but unless the people themselves, the people who really face the challenges, speak and come and join you when you're speaking about all these issues, then you're not going to manage it. So we had that vibrant disability movements who supported us in lobbying the government and helping us coordinate some of the activities of the government. And then another thing about the lessons learned is about designating a body that has had prior experience on issues of disability. Because if you look at the Kenya National Commission on Human Rights, and you look at the background itself, when they started doing these activities, even when they were standing committee in 2005, before they actually became a constitutional body, they were still talking about issues of persons with disabilities. So for us, for Kenya National Commission on Human Rights being designated as independent mechanism was like something that was there, and now it's being affirmed. So it was a really plus because it was picking up or continuing what we have been doing. And then I talked about designation of independent mechanism of an NHRI because of the independence itself, and especially if it's a constitutional body, in terms of budgeting, in terms of the personnel, hiring of personnel, in terms of the activities itself, especially the quasi-judicial aspect, which is required in the monitoring, because you may have limitation of visiting police station as a DPO, as an NGO, but for a national human rights institution, for example, in my case, you are allowed to visit all this. You don't even have to issue like a letter to go, but you can even make the impromptu. So some of these challenges we are facing in terms of getting our data, in terms of getting information, we can actually see how we can work with national human rights institutions, especially the ones that have quasi-judicial mandate. And then the other issue is about political will. It's very important. we have the election quotas within our constitution, and this has been a plus for us because we have persons with disabilities who are nominated or elected within the parliament, and they have a caucus. So we have been able to work with the caucus. So when we talk about issues, then we have someone in the parliament or the National Assembly or the Senate who are able to bring the issues at that level. So we have the National Commission preparing advisory, but the same advisory being fed to the people within the parliament so that they can advocate for the issues within those, within the Senate and the National Assembly. And then the last one is about creativity in terms of financing, especially through international cooperation. And I must emphasize that it's basically about how you write your proposal, because for us, when you're writing our proposal, we had to highlight the issue of persons with disabilities. So if we are getting, like we are negotiating for any funding from any development partner, then we have to tell them that one of our key output in our strategic plan is about implementation of the Convention on Rights of Persons with Disabilities. So if we are talking about getting funds for monitoring election, we have to get funds as well for monitoring certain aspects of persons with disabilities, and this means getting more personnel on this and this. It means getting more having conversation with the DPOs to do this and this. So all those activities will be reflected within your proposal. So how creative you are in terms of bringing the discussions to the development partners is very key when it comes to implementation of activities of Article 33.2. And those are just some of the photos during our monitoring the counties. You can follow me on Twitter at Miriam Denges.
Thank you so much, Miriam. Yet again, you remind me of the failings of my own country, and you're underscoring that that human rights treaties, when ratified in Kenya, actually have direct effect. This makes me sad. Not so in the United States, but we don't ratify treaties anyway, so we don't even get to that point. And we don't have a National Human Rights Commission either. But I think your presentation of the case study of Kenya is really important. I think your point around disability-specific and mainstreaming is a lesson that we need to take to heart, not only when thinking about disability inclusion in a National Human Rights Commission, but in other institutions and structures across government. Really, really important. We really can't talk about mainstreaming unless there's capacity to start with on disability issues. So really important point, and taking advantage of the national human rights institutions and mechanisms is really important for those of us who work on the civil society side. There's around 100 or so of these national human rights commissions around the world. Putting disability on their agenda is incredibly important. Not all are so up on disability issues as the Kenyan human rights mechanism, but that's really part and parcel of the work that we do, and the many of them, if they are really compliant with international standards, will have a complaints mechanism, which is another really important advocacy portal. Okay, so now we're going to go to our final panelist, Frank Conatee, who has a very interesting background as an accountant, a lecturer in accountancy and finance at NUI Galway, and he is doing work currently on performance measurement and management in the provision of public services through nonprofit organizations. He is a commissioner of the Irish Human Rights and Equality Commission, and he's going to give us his take on monitoring in this context.
Thank you, Janet. Well, good morning, or probably good afternoon maybe at this stage, I'm not sure. And thank you for inviting me today. Just get... I only have 2 slides, so...
Was it worth it at all? Here we go. There we go. You have 3.
I have 3, but the first is just my name.
Right.
My purpose here today, as I understand it, is to talk about the role of national human rights institutions, NHRIs, in monitoring the human rights record of the state as it affects people with disabilities, and their role in the promotion of human rights of peoples with disabilities. In that context, it will be necessary for me to confine myself to the case of Ireland, as that is what I am familiar with. Let me start by explaining, as Janet has said, that I am an accountant by profession, and I feel somewhat out of my comfort zone with all of the legal and policy experts that are present and around. I'm a lecturer in accounting, auditing and corporate governance at the Business School, and I'm also Commissioner of the Irish Human Rights and Equality Commission. The Irish Human Rights and Equality Commission, IREC, came into being in its current form on the 1st of November 2014. Prior to that, we had two bodies, the Irish Human Rights Commission and the Equality Authority. IREC is composed of 14 independently selected commissioners, of which I am one, together with the Chief Commissioner, Emily Logan, who unfortunately cannot be as planned, she was planned to be here today but can't be with us, and sends her apologies. IREC is staffed currently in process of recruitment with a team of legal, policy, research and training professionals. My interest in human rights and equality stems from an involvement of over 20 years as an advocate and at times agitator for rights and services for people with intellectual disabilities, born out of family circumstance. The arrival of our wonderful son Matthew, now 21 years old. Matthew has profound intellectual and physical disabilities. A particular challenge for some people with disabilities is visibility. So I like to bring Matthew with me, if not physically, then in spirit, when I talk on the topic of disability and rights. Visibility is a central part of my message today, and what I have to say resonates with Saoirse's and Miriam's presentation. I should point out at this juncture that what I am about to say are my own personal observations and thoughts, and not any official line of IREC. While IREC has an overarching mission under its establishing legislation to protect and promote human rights and equality, it also has a number of specified direct or hard roles in the monitoring of human rights, together with a number of specified indirect or soft roles that are of equal importance. I will talk of this later. Before exploring the roles of IREC in relation to human rights and disability, I need to outline, I feel, what I like to call the disability human rights architecture in Ireland, as no NHRI acts alone or in a vacuum. This architecture may look similar in other jurisdictions. So if I may, for a moment, and this is by no means the definitive schema of this architecture. It's my effort to try and capture this particular dynamic. I've placed people with disabilities at the centre. At the very outside, I have what I call contextual matters here. We have, for instance, the government departments, government policy, health and education, legal and law enforcement context, the international disability and human rights context, EU and UNCRPD, etc., and other conventions. And very importantly, in context, is societal attitude. Closer or more proximate to people with disabilities, I've divided this into 4 quadrants. We have service and what I call life supports: health, education, social services, voluntary bodies, family and carers. We have regulation, standards and oversight. In Ireland, we have the Health Information and Quality Authority. We have the National Disability Authority and others involved in regulation and oversight. We have external complaints mechanisms. We have now in disability a confidential recipient in terms of residential care. There's an ombudsman. And of course, there's the Irish Human Rights and Equality Commission. And this quadrant I call voice. We have national advocacy groups. We have the National Advocacy Service. Again, the confidential recipient has a role to play. We have disability organisations, and we'll talk of them later. Family and carers again, and the Irish Human Rights and Equality Commission. I'm not suggesting this is the definitive schema, but what I want to point out is that it is complex. And recognising actor complexity and the interdynamics involved is the first step, I believe, in being an effective actor. And the Irish Human Rights and Equality Commission and NHRIs are one of those actors. IREC's role is primarily one of human rights oversight and promotion, with the power of inquiry and direct action when necessary. It is important, however, that IREC has a good working relationship with all of these actors. Without these working relationships, it is very difficult to see how IREC would be able to play an effective role in monitoring human rights for people with disabilities. It is also important, in order to be effective, that IREC does not do anything that would effectively displace the existing roles of these actors. These are common challenges for all NHRIs. In Ireland, for example, the Health Information and Quality Authority that I mentioned, HIQA, has a particular role to play in the monitoring of residential settings for people with intellectual disabilities. This function only commenced in November 2013, but is already having a significant impact in highlighting human rights violations and providing an impetus for change. Other actors have monitoring roles to play, such as the Ombudsman, and indeed the state bodies responsible for health and education services. NHRIs, like IREC, to be effective, need to support these organisations in ensuring that they engage in a human rights approach and that they are adequately trained. Indeed, for the public body actors, IREC has a legislative obligation to do so through its requirement to support what's called the positive duty obligation of public bodies in upholding human rights. The legislation that established IREC sets out IREC's formal roles. Disability is a cross-cutting phenomenon, and there are no aspects of public or private life where disability is entirely unknown. In consequence, all of the roles and functions of IREC, or any NHRI for that matter, are relevant to people with disabilities in a disability context. Direct monitoring functions and powers of IREC include, for example, to keep under review the adequacy and effectiveness of law and practice in the state relating to the protection of human rights and equality. That's all laws. To examine any legislative proposal and report on any implications for human rights. Again, all legislative proposals. To make recommendations in relation to the measures the Commission considers should be taken to strengthen, protect and uphold human rights and equality in the state. To appear before the High Court and Supreme Court as amicus curiae in proceedings of relevance to persons with human rights or equality issues. To provide practical and legal assistance for persons in vindicating their rights. To institute court proceedings for declaratory relief in relation to the human rights of any person. To conduct inquiries into human rights violations, either specific or systemic, which can lead to enforceable compliance notices, a quasi-judicial function. It should be noted that for the most part, other than legislative reviews, the instigation of such direct actions by IREC would have to necessarily emerge from a third-party contact, request or revelation. This points up a key observation I would like to underscore here today. The effectiveness of NHRIs and IREC is dependent on their engagement with society and vice versa. In relation to people with disabilities, this means through engagement with individuals, support and advocacy groups, and key actors of the disability human rights architecture as set out earlier. Without such engagements, these direct actions that IREC can instigate in the area of disability will not be maximised, thereby undermining overall effectiveness. In this context, the less formal and more indirect roles of NHRIs, like IREC, are of critical importance. Such roles are specified for IREC in its establishing legislation, and can and should be interpreted as broadly as possible. Those roles tend to be of the nature of promoting, providing assistance, encouragement, working towards goals. Some examples on indirect monitoring roles from the NHRI legislation in Ireland for IREC are to work towards the elimination of human rights abuses, discrimination and prohibited conduct, to provide information to the public in relation to human rights and equality generally, to undertake and sponsor research, to provide assistance in the provision of education and training on human rights, to assist public bodies in meeting their positive duty obligations, to consult with such national, European Union or international bodies or agencies having a knowledge or expertise in the field of human rights or equality as it sees fit. These are just examples. There are others. It is imperative that NHRIs like IREC secure the space to carry out their role in all of these areas and to promote active engagement from the disability community. It is imperative that the disability community proactively engage in this regard. IREC is an A-status NHRI. This gives IREC a top-table calling card in gaining the audience at international human rights tables in Europe and at the UN. 2 weeks ago, IREC opened the UN Committee on Economic, Social and Cultural Rights review hearing on Ireland's third periodic report on compliance with the International Covenant on Economic, Cultural and Social Rights as we head from Saoirse. IREC took the opportunity to devote 1/3 of its opening statement to human rights of people with disabilities. And human rights issues for people with disabilities were highlighted across all of the article headings of the Convention in IREC's written submission to the UN Committee. The process is outlined by Saoirse. It was heartening to experience the openness and willingness of the committee members to engage directly on issues of human rights for people with disabilities in what was a packed and busy agenda. The committee published their concluding observations this week. Overall, in terms of ISESCA, the observations are strong. They're welcome. Welcome in terms of the assistance such observations can provide to all human rights observers, but IREC in particular, in monitoring the state's record in terms of economic, social and cultural rights. It was good to see certain human rights issues for people with disabilities being highlighted in the observations. In particular, the ratification, or rather the Irish state's non-ratification of CRPD, the need for continued progress in deinstitutionalisation, and the lack of implementation of the Education for Persons with Special Needs, or EPSEN Act, amongst others. I was personally somewhat disappointed, however. I had hoped that the failure of the state's national disability strategy and that the lack of a credible, integrated and resourced national strategy to carry us into the coming years might be highlighted as a significant undermining factor for people with disabilities in experiencing equity of access to and expression of their human rights. Indeed, it can be argued that such an absence facilitates human rights violations and abuses. A final observation coming away from the Irish ISESCA review process is that the disability community, in terms of civil society involvement, was not at all as evident as that of other interest groups. This leads me to something that I have come to recognise over the past 20 years that I refer to as the noise. There is a lot of noise in the world. There is a clamorous cacophony of voices, legitimate voices, looking for attention and assistance in accessing and upholding their human rights. The disability community has a number of significant challenges in this regard. First, disability, as mentioned earlier, has implications across all facets of human existence: health, education, housing, physical and non-physical access, employment, gender issues, ageing, sexuality, reproduction, and on and on. Secondly, and partly because of the cross-cutting nature of disability, but not exclusively so, the disability community itself is a fractured community. There is a blinding array of service, support, and advocacy organisations and groups, with divisions along many lines, including the nature of the organisations themselves, some of which are unitary in nature and some hybrid. Some focus on only physical or sensory disability issues and some only intellectual disability. Some are focused on one type of disability and some are or try to be umbrella organisations. Some focus exclusively on people with disabilities and some on carers of people with disabilities and their families. All of this introduces further noise. Third, people with disabilities and their families and carers have particular challenges in self-advocacy, not least one of restricted capacity in terms of time and energy, physical and emotional. People with disabilities, their families and carers, while motivated, are often at the limits of their capacities and reserves to exist, never mind actively engaging in self-advocacy, lobbying and campaigning. All the more reason to applaud what is achieved in this regard. One particular result of this is that disability organisations at a local and indeed national level can and do wax and wane in their ability to actively advocate. In fact, there are constantly emerging and disappearing organisations, born out of the energies of a few, followed by many, but when the original few are spent, there's no one to take on the task. NHRIs, like IRIC, to be effective, have to recognise this. NHRIs, to be effective in monitoring human rights, have to find a way to listen, to hear the human rights messages, and to support human rights advocacy activities in the disability community. But NHRIs do not have unlimited capacity themselves. NHRIs have to make decisions on where to focus to be effective. To make informed decisions, NHRIs have to engage with society through all of the indirect roles mentioned earlier. In this regard, the disability community has a role to play in such active engagement, to help in identifying and making visible the disability pattern in the human rights clamour and noise, to help NHRIs make informed and relevant decisions on how to effectively monitor and act when human rights are at risk or violated. It is imperative, however, that we continue to press for ratification of CRPD, that we work to remove any real barriers to ratification and dispel those that may be false. CRPD is, in my view, a potent mechanism to unify the voice of people with disabilities in the human rights noise. A mechanism that can be harnessed by NHRIs and the disability community, and particularly when ratified with an effective, structured monitoring mechanism involving NHRIs. As regards IREC, we are open for business. We are engaged in developing a programme of outreach and consultation, and we are looking forward to listening and informing our role as an NHRI for people with disabilities in Ireland. Effective monitoring of the state record in protecting and upholding the human rights of people with disabilities by NHRIs requires active recognition, support and use of the human rights architecture and its key actors. In this regard, I'd like to mention specifically the need, as mentioned by Saoirse and others, for reliable, disaggregated data, without which we cannot effectively monitor human rights. In Ireland, for example, the the Health Research Board has, in one facet, an obligation or has a role in maintaining a database on intellectual disability and another on physical sensory disability. By its own admission, nearly 50% of the data in the database is inaccurate. Secondly, effective engagement with international human rights monitoring and enforcement mechanisms, in particular European and UN mechanisms. Third, proactively supporting ratification of international human rights treaties, in particular CRPD and the attendant monitoring mechanisms. Fourth, proactively listening and engaging with the disability community and supporting people with disabilities to active advocacy through their indirect human rights monitoring roles. Finally, making informed decisions on the best use of their direct human rights monitoring mechanisms. Thank you.
Thank you. Thank you very much, Frank. I hope that we've all heard about the necessity of conceptualizing disability rights monitoring nationally as multidimensional, as complex, and as conferring obligations on not only national human rights institutions that have an incredibly broad, far-reaching mandate if they're to be compliant with international standards, and usually not enough resources to possibly come close to really answering that mandate, but it also confers obligations on DPOs and disability advocates to engage proactively with national human rights institutions. And indeed, the CRPD in Article 33 gives monitoring obligations to governments and NHRIs as well as DPOs and civil society. So really, really important case study of Ireland. And I think lots of lessons learned for us. So thank you so much. Okay, let's open it up for some questions. Let's take several questions and comments. I'll take a round of 3 or 4, and then we'll hand it over to the panel for a response. Okay, we'll start up here on the left. Got two over here on the fourth row on the left. Eka, we'll start up here.
Sorry, leave that one there.
Okay, yes.
Thank you very, very much. First of all, I'd like to congratulate all the three speakers. It was a wonderful presentation. My question is, I could just ask any one of them. When you are talking about effective participation of people with disability, what are the things which we are looking at? For example, if it's an organization like the National Commission for Human Rights have called for a meeting, are you looking at the number of people who have participated in that particular meeting? Are you looking at the number of organizations which have participated in that meeting? Or are you looking at the impact, for example, on what transpired, for example, after the meeting? I mean, what are we talking about when we're talking about effective participation? What exactly are we looking at? That's the only question I have.
Thank you. Can you pass that down?
Thank you, the presenters, for the wonderful presentations. My inquiry goes to Brady. In her presentation, she said there was a dichotomy in the data presented in the alternative report and the state report. Probably would like to learn how that was reconciled. I know there is an issue to do with disability data, but how was that reconciled at the time of presenting the alternative report? Or this being the de la creme, de la creme, the disability advocacy, how can we narrow the gap in the contrasts between what the state parties present in terms of data and what the civil society is also present in terms of data? Thank you.
Thank you. Can we shift to the other side of the room now? Yes.
Yeah, so I think my comment nicely dovetails on that, and give me, be patient while I try to set it up, because the examples that you gave from Ireland, though there's still a long way to go, it shows there's a cooperation and goodwill on the part of the government and a lot of actors. But I want to ask a question about a country where I'm currently working, and I work for a funder, Open Society Foundations, and a country that's backsliding in terms of democracy. And with one organization there that we work with who has recently, and I won't say the country, but you can probably figure it out. They have just, a grantee there has recently undergone a month-long sort of on-site investigation by the Federal Prosecutor's Office and the Ministry of Justice, which found indicators of foreign agent activity, not just in their funding, but in their public critiques of government decisions. And the Ministry of Justice actually used a CDAW shadow report to find this. They found within the report this evidence. So my question is about monitoring in a larger sense. I think if we think about the implications across human existence and that disability is part of them, what does it mean? What does this type of government activity mean in types of international cooperation, in recommendations that we might have? Are we producing parallel reports that go nowhere, that sit on shelves? And also, by supporting civil society and making sure they have a voice in the process, I feel like we're actually also undermining them. So that's my conundrum right now.
Thank you. Another question on this side of the room? In the back? Yes, please.
Yeah, I'm happy. Frank, I'm just going to from St. Petersburg, living in Ireland. I'm just wondering, you said earlier on about disability organizations. Should they take more active role in work of equity? I know including Ireland in Ireland, it's kind of would see themselves as, because of the role in the intellectual disabilities as a watchdog. Are you saying more disability organizations should take more active role in that field, or or it's okay if it is.
Okay, can we have a round of response from panelists?
Hello. Yeah, I might maybe take two. The first question, the last question, which are interesting in terms of participation. I think there was a question: is it about numbers or about impact? And the latter one then basically linked to that is whether more organisations should get involved. And I think my opinion or my observation over the years of that is that there is an ability for people and organisations to engage at different levels. And it is incumbent on national organisations such as the IREC to ensure that they have the ability to also engage at all of those levels. There is a validity in the voice of people in national organisations, and there's also an extraordinary validity and necessary need to listen to the voices of people at different levels within civil society organisations. And when we talk in terms of people with disabilities, it would be, in my view, it would be inappropriate for the likes of IREC to confine itself to discussing issues to do with disability rights with national organisations and not engage also right down to the grassroots, right into the lives and talk to the people in local organisations and across society. That is the challenge for NHRIs. The challenge for disability organisations is to be open and engaged with that. And I would also then see, in terms of this engagement, a significant role for the likes of IREC and the state to play in supporting people to have a voice, in supporting voice and advocacy. And there is a role for NHRIs to ensure that the state applies its resources for mechanisms and ways of ensuring that people can be heard. An example would be, in terms of Ireland, we have a national advocacy organisation. And that national advocacy organisation, while it is somewhat effective, in my personal view, it is not sufficiently underpinned by power and by resources to be an effective advocate, an effective voice. So there is a role in terms of ensuring that there are mechanisms that are there to facilitate people to be heard. And NHRIs can play a significant part in that, in ensuring that the state is meeting its obligations to support people to have voice. In terms of whether there should be more organisations involved, it's not a question of more or less. It is a question of having supporting an ability to allow organisations to express and for organisations like NHRIs to listen. So in terms of Ireland, you mentioned the inclusion and their role. There are certainly significant organisations in terms of disability that have a more powerful voice because of their size, and they will and can get to the table and be listened to. And again, I'll emphasise, it is not just one of those organisations, it is the other organisations throughout society, throughout the disability community that need to be listened to. So I'm not advocating more or less, I'm advocating quality and ability to listen and be heard, and to allow voices to make a difference in terms of decision making. As I pointed out, I think for any NHRI, they have capacity issues and there's a cacophony of voices there. And allowing the voices to be heard and seeing the pattern of where we need to apply ourselves in terms of applying our own resources as an organisation, as an NHRI, to combat issues of human rights abuses. And I think that's really what I mean by trying to support engagement. In terms of disability data and assessment, I think Saoirse might be able to talk about that.
Yes, so just in terms of civil society as well, the consultations, I agree with what Frank said. And one of the important things about it isn't about how many people come along, it's about who comes along. Because otherwise it turns into a tick box exercise, and what we often see are states saying we've held a consultation with children, young people, or persons with disabilities, and they fill a room full of people, and they say, well, we've consulted now, that's fine, and that's not what we want to replicate. And certainly one of the reasons why we went with the Civil Society Shadow Report while we went to various places was that people in different parts of the country experience issues in a different way. You know, when we came to Galway, one of the key things that came up was around rural transport, which wasn't something that came up in Dublin, because, you know, there are different things. So that was one of them, and so I think it's really important to engage with the bigger organisations on a national level, but then also to engage at a local level, and to do your research and find out who you should be talking to as well. And, you know, for the Civil Society Report, we did have input from disability organisations, but, you know, it wasn't as much as maybe from some of the other sectors. And I think that was partly to do with the lack of resources, the lack of capacity, and even at one point we had a leading disability rights activist who was lined up to come along to one of the consultations, and, you know, we've been in touch, and I was very excited about this. And she couldn't come in the end because she works in an organisation that advocates on behalf of people with disabilities, and something came in the door that morning that she had to prioritise. So we have to be mindful of that as well. But, you know, the disability organisations do a lot of very good work, so we use that in the report. And in terms of the dispute over data, this came up particularly for ICESCR. It came up in terms of poverty statistics and the data that was used by the state on one hand and by civil society and on the other. What I'd say, it wasn't reconciled because there was clearly a difference of opinion. But what I would say is we were very careful to use the officially recognised data. We were using EU SILT data, you know, the Survey on Income and Living Conditions, and that's the data that's used in the National Anti-Poverty Strategy. So we use the data that they are meant to use themselves, and the state were saying, well, it isn't always accurate. We have this other data that the Central Statistics Office pulls together, and that's more accurate, that's a more accurate reflection, and perhaps that's so. But when they're reporting to the EU, it's EU SILT data that they use. So we used that. We were very careful to use official data and make it very clear. And also, what we did is make it very clear how that data is collected, and make sure the committee were aware of what that data actually represents. Because obviously there are different measures for different things. So that was one of them. And in terms of your question about shadow reports lying on the shelf, and that should be my last slide actually while I was sitting here thinking about it, and whether or not using shadow reports or parallel reports can undermine civil society. I don't think that they do. I can see in certain instances where that could be done, but again, it's about making sure you have the correct evidence, that you've backed it off, that you're able to stand over it. And I think the key with both the shadow reports in this instance is about implementation. It's about what happens next with them, and you know, the actors involved are very keen to make sure that they don't just sit on a shelf, that you know, that they are actively monitoring whether or not these are implemented and how to do that. And there are a number of ways. So Ireland's coming up again for its second universal periodic review in next year, and we have to submit information this autumn in order to look at that. And we have been examined by a number of international bodies in the meantime. And even when we're reporting to the UN, we don't just concentrate on what other UN bodies have said. We look at Council of Europe, we look at we look at other regional mechanisms and national mechanisms as well. When my colleague from Henny here was talking about the direct applicability of international instruments in domestic law, I'm very jealous because we don't have that, and that's the argument that's put forward all the time by our state when they go to Geneva or Strasbourg or wherever. So we will monitor whether or not they're implemented, but I think we have a body of work to do to make sure that they don't just sit there. We build on the momentum from the current recommendations from various committees, and if you look at them, a lot of them are the same. You know, they come up time and time again. So that does create some kind of momentum of pressure to place in the government. We now have the commission in place, which I think is great, and they came out hitting hard on ICESCR and kind of putting down the marker to show we are here, we are going to be monitoring these things, we are going to be calling the state to account, and accountability was a huge part of the commission's report certainly. And what they're calling for now is that there will be parliamentary oversight of that, and that's a big push. You know, we need a mechanism to oversee. Like it's all very well the state going and presenting to these committees, but we need a way to implement it on the ground. We need oversight. We need it not just to be a talking shop. Otherwise, they will just sit in the shop and do nothing. So I'm not sure if that was most excellent.
Miriam?
I just want to add on what my colleagues have said. In terms of effective participation of persons with disabilities, it's more of the impact, the output itself of what you are discussing about. If it's about legislative reforms, are we just getting persons with disabilities to come and sit in a conference and then give feedback, and at the end of it all, it's the reflection of what we want as government. So the end result is the most important thing. It's about how you even start the process itself. For example, if we want to discuss issues of Article 12, how did we begin the process? Did we go and have consultation sessions with persons with disabilities? Did they highlight the key issues that they want for you to like lobby within the government, or is it an initiative that you did on your own? Did you highlight the issues themselves, or the issues themselves that were coming from the people being affected? And I think this is one of the things that is being driven by the legal capacity movement that tries to document the voices of the people themselves, so that their voices are the ones that are driving the change. So it's basically about the initiative themselves, how you initiate your processes, and how you end them. So you begin with persons with disabilities and their representative organizations, and then you start lobbying, and at the end of it all, we also want to see the issues that were at the initiative place being at the end process. So it's about the end result itself reflecting those voices throughout. Like, we are not going to lose any voice in between, whether from the grassroots level, whether from the national level. But at the end of it all, we are going to have a reflection of those thoughts from the initial process to the end process. So for me, that is the interpretation of active and effective participation of persons with disabilities in the monitoring process.
Thank you. I think I can summarize what the three of you just said. Human rights reporting needs to comport with human rights principles, whether it's being done by states, NHRIs, or civil society organizations. So participation, inclusion, do no harm, ensure that your information is reliable, credible, ensure that you actually have a strategic plan for using this kind of advocacy, so that it doesn't sit on the shelf, and as engage international actor, ensure that you're working with local groups to forward their advocacy, not to forward your own donors' requirements. That is absolutely fundamental. Let's take some more questions, comments, right up here, right here in the front.
I apologize to do this before lunch because it could take a little while, but as an individual who acquired his injury not so long ago, I received care from two different providers, care or support, whatever way you want to say it. And the first provider would have had no implementation for a complaint procedure. So anything that I would have had would be falling on deaf ears. So we had to implement that ourselves, my family and myself. And the next part is the second provider. Any complaints that we did make was met with contention, was met with the fact that I wasn't taken seriously on any occasion, and to the point where I had emotional, physical, and psychological scars to deal with this, and dealing with this, and so did my family. These things build up on an individual and the people that they love and have affection for. And what I'm saying is there's not always an organisation to appeal to that. There's not a person that you can go and say, well, I've had a complaint given to the supervisor, and the supervisor does not really complain, so don't take that seriously. And it's very hard to be truthful in every occasion to many different organisations and advocates. What I'm trying to say is the individual isn't being looked at here. Not everybody has a voice to be able to speak. Not everybody can be able to write an email, which I was able to do, or make a complaint through a formal process to make sure that this is going to be processed. So there's a lot more that needs to be done for the individuals themselves. We can't be relying on organisations for them to take on MBS.
Thank you. Okay, I think we need to wind up. Can I have any final responses to this?
Well, can I just respond to that? I think it's unfortunately not atypical, and it points up the need for the whole issue of advocacy to come up more to the forefront in terms of national policy. And we do, as I said, we have a national advocacy organisation, but it needs to be more robust. And the role then of the rights of HICWA in ensuring that in terms of residential settings that standards are met, we will have the HSE with the new set of requirements in terms of day services and stuff in terms of people with disabilities. But I think it goes back to the architecture. It's not just about one thing. It's about ensuring that we have, for instance, the Ombudsman is there, we have the Irish Human Rights and Equality Commission, we do now have a confidential recipient we didn't have before, the National Advocacy Service. And I am absolutely, in terms of advocacy, I could talk all day about it. And I think one thing that has happened in the Irish state, which is interesting recently, as a result of issues in the acute medical side in terms of hospitals in our country to do with maternity services in and around Portlaoise in the Midlands, where there were significant issues of potential practices that were not just inappropriate but could end up being found to be more than that the state had to respond. And one of the responses that the state has agreed to is to ensure that there is an advocacy service for people in the acute health setting. And that is, to my mind, points up the need for advocacy, not just in disability, but throughout society, when you have people who, for whatever reason, do not have the capacity in that moment, it may be temporary, to advocate for themselves. But the fact that the state has agreed, as a result of the Portlaoise situation, to have a national, properly structured advocacy service in the acute health setting, that it points up the need to make the national advocacy service in the disability sector a lot more robust, have a lot more teeth, and be able to actually advocate in an effective way, which is not there.
You have to wait for something like that to happen.
Indeed.
Thank you. Thank you. Very much great panel, very dynamic. We can now convene for lunch. Just a quick reminder that the moot preparation at lunchtime, the World Bank team will be in 006, the DPO in 008. So grab some lunch, and you're encouraged to continue to prepare for the moot.